Welcome back to this third segment of Law Sessions Leasehold Covenants, and we were discussing before the break the idea of having the relationship insofar as the landlord and tenant prior to 1996 having certain types of obligations. Now, just before we went into the break, I asked you to visualize the relationship being, for example, the landlord at the top, the tenant at the bottom on a vertical line, and then from the tenant, a horizontal line to A1. I would suggest actually that at this point, you may want to get pen and paper and at least draw that so that you'll be able to work with it, because it is going to get slightly more technical as we go along. So if you were to draw the shape L, then we would have, as I say, the landlord at the top, the tenant at the bottom, with the assignee at the other side. Now, you could have what is called, or what looks like, a reverse L, where you have, for example, the landlord, the person to whom he sold the reversion at the top, so a horizontal line, with a vertical line from the landlord to the tenant. But as I say, it would help if you did have some kind of writing instrument in order to make sure that you are keeping up with this lecture. Now, when the landlord sells the reversion, the lease, or sells the reversion to a new purchaser, so that would be your horizontal line from, say, L to P, then if the landlord sells the reversion to P1, for the remainder, P or P1, take your pick, it's the same person. So let's call him P1, because P1 might sell to a subsequent purchaser called P2. So when the landlord sells the reversion, for example, to P1, for the remainder of the duration of the lease, privity of contract will remain as between L and T, that's the landlord and tenant, as they entered into a contract with each other, but after the sale, there will now be privity of estate between the tenant and P1. Now, the usual exam scenario, of course, is imagine a square, because the usual exam scenario is where you have L to T, and then the examiner will say L sells to P1 and T assigns to A1, and you now have to discuss the P1 to A1 relationship, and that is where you need to understand what the legal rules are prior to 1996 and post 1995, so from the 1st of January 1996. So as I say, L sells a reversion, sells it to P1 for the remainder of the duration of the lease, though we see that T assigns the lease to A1 for the remainder of the duration of the lease. Again, I will remind you that when we talk about assignment, it's when you give everything that you own, all the rights you own. So if I have a 50-year lease and I've already used up 20 years, I can assign 30 years. But when you talk about a sublease is when you give, or rather, when you retain at least 1 day less than the interest you have. So again, if I have a 50-year lease and I sublease, so I have 30 years remaining, and I sublease 29 years and 364 days, for example, it will be a sublease. It's not an assignment because it will revert to me after the end. So privity of contract remains between L and T as they entered into a contract with each other, but on the assignment, there will be privity of estate between P1 and A1. Again, I want you to visualize a square. So privity of contract will exist between the original parties, and privity of estate will exist between the new parties. So the new current landlord P1 and the new current tenant A1. Now then, if that is the case, what burdens and benefits will pass to the new party and which do not? Well, the new party, let's look at the assignment, A1, will acquire the burdens and the benefits of all covenants that touch and concern the demised premises, the leased land. This rule was established in the case of Spencer's case. And Spencer's case says, of course, that there must be privity of estate between A1 and the person wishing to enforce it, or whom enforcement is sought from. Now, I know that I say to you that the usual is a square where you have L to P1, L to T, but T to A1. But there may also be a situation where you have L to T, but then L only sells to P and T remains in the landlord-tenant relationship. So you could legitimately have a situation where one of the parties, one of the original parties to the covenant remains in the relationship. And I want you to bear that in mind. Now, the relevant covenant that touches and concerns the demised premises, for example, case to consider is P&A Swift Investments and Combined English Stores Group, defines a test for touching and concerning the land. The questions you must ask are whether the covenant ceases to be of benefit if it does not pass to the assignee, and whether the covenant affects the nature, quality, and mode of the user, meaning use, or value of the land of the reversionary. And again, remember that reversion simply means the land is going back to the freehold reversioner or the leasehold reversioner. That the covenant is not expressed to be personal. Because if it's a personal covenant, the kind of way you see this on exams is when the examiner tells you that one of the covenants is for B to wash A's car or something like that. That's a personal covenant. It will not touch and concern the land. In relation to money, whether it is connected with something to be done unto or in relation to the land, examples of such covenants that touch and concern the land, therefore, covenant to repair or build on the land, or for the landlord to provide services on the land, a covenant to maintain insurance, covenants relating to the use for which the premises may be put. Now, personal covenants between the landlord and the tenant, benefiting or binding, say the landlord or the tenant, will only be binding on the original landlord and tenant and will not run with the land on the assignment or on the sale of the lease. Now, what about liability and enforceability? You can only take action against those you have either privity of contract with or privity of estate with. So what if the tenant changes? You can only take action, as I say, against those you have either privity of contract or privity of estate with. And you can only sue one person. So what if L to T scenario, but then let's assume T assigns to A1, A1 assigns to A2, A2 assigns to A3, and A3 assigns to A4. Well, again, it looks like an L, but you'd have to imagine that there are broken lines between each of the assignees. So you'd have L to T, T to A1, A1, another dash to A2, and so on. But you would only have one continuous line from L to A4. Because now what we have is A4 is the person in occupation and possession. It means, therefore, that L and A4 are in privity of estate and L and T are in privity of contract. So here, L can only sue one party, and therefore the landlord will sue the party who they are likely to recover monies from. But of course, the landlord can only sue a party, for example, who he's in privity with. So in this case, he can only sue T or A4. But does that mean, for example, that A2 and A3 are out of the loop? Well, I will touch on that later, but the best option, of course, is for the tenant to get an indemnity when he actually assigns to A1, and for A1 to then get an indemnity, and so on. So that if A4 doesn't pay and T has to pay, T was not the one assigning to A4. Rather, it would have been A3. So how does T get his money back? And that's why I'm saying you would obviously look at possibly indemnities. Now, A4 can only be sued for the covenants that touch and concern the land. So if between L and T, the type of covenants include, for example, a personal covenant like T washing L's car, that of course will not bind A4 when, for example, L says to A4, you are now the person living on the property, you need to wash my car. It won't work like that. So A4 is only liable on covenants which touch and concern the land and which exist by virtue of privity of estate. T, who is the original contracting party, will remain liable for the full duration of the lease, regardless of whether the tenant has sold, assigned, or transferred their interest. The tenant will therefore wish to protect his position when he sells, assigns, or transfers the interest. And this is where I'm telling you that the best option, of course, is to get a series of indemnity from the various parties. So again, if T were to, for example, get the indemnity from A1, A1 from A2, it just means that if T is then sued by the landlord because T is in privity of contract, he can then, of course, engage the indemnity in order to get his monies back. What if the landlord changes? So what if we have L to L1 to L2 to L3 to L4? Or purchaser 1, purchaser 2, purchaser 3, purchaser 4, whichever. But let's use L for landlord. Here, the tenant can sue the landlord if the tenant breaches a covenant, the tenant can sue the landlord if the landlord breaches a covenant, as there is privity of contract between the parties in relation to all covenants, unless L has applied for a release when he disposed of his interests. Alternatively, T can sue L4, as there is privity of estate between the parties in relation to covenants which touch and concern the land. So L1 to T, L2 to T, L3 to T, and so on. When L assigns the reversionary interest, he loses his right to sue, as basically L divests himself of all the rights to enforce the covenants. Now, this is interesting because the point here is that as it relates to a tenant, I want you to grasp this last bit here, because if a tenant, for example, is in a relationship of landlord and tenant where the new landlord does not repair the roof, and let's assume that was a covenant on the contract between the parties, the tenant can choose to sue landlord 4, the current landlord, because there's privity of estate and it touches and concerns the land, or he can choose to sue L because there is privity of contract. He is the original covenantor as it relates to the covenant of repair. But here is something you need to further consider. Because L has divested himself of the property, let's assume that T does not pay the rent. Where L has divested himself, unfortunately, L4 is the only one who can bring an action against T. L cannot, and that's notwithstanding privity of contract. Now, we will pause there, and when we return, we will touch briefly on subleases, and certainly we will also look at the context of forfeiture as it relates to leases.